And hopefully also Eleonora will be coming in through this channel.
Okay, now I can hear you. It should be working. Everything should be fine. I joined through my phone because I think it's easier because the laptop. Okay.
Okay.
No, should be working.
Yeah.
I'm sorry.
So we're already people are coming in, Eleonora, but it's good to hear you, good to see you, and I hope that our technical issues are solved through this channel. Yeah, and to the others coming in, welcome. We'll just take a couple of minutes more. It's also not yet 1 o'clock. So thank you for being on time. We'll take a couple of minutes for everybody to log in, and then we'll kick off this webinar. Welcome to everyone joining to this joint webinar on strategic litigation. We're just taking a couple of minutes for the people to join, and then we'll kick off.
Hi, good afternoon.
Welcome, Siham. Good to have you. We're just waiting for people to join, and then sure. We'll start. Yeah, thanks.
Yeah, sure.
Right, good afternoon, everyone. As you could already see in the chat, this webinar is being recorded. So just so you know that that's happening. And I'm going to start slowly with my introduction and then get to the speakers of this event. So welcome to this webinar. It is hosted by Horizon Europe project DignityFIRM, and it's part of a joint webinar series of 7 Horizon Europe projects, which all touch on aspects of irregular migration. Just a little background on the DignityFIRM project. It is driven by the ambition to deepen our understanding of and, importantly, improve law and policies that shape and influence migrant workers' rights. And we focus on the rights of workers in the farm-to-fork sectors in the European Union and beyond. And beyond in our project means Ukraine and Morocco, and it's good to see that our Moroccan partners have also joined the session. Migrant workers play a pivotal role in food production and the distribution of food, the preparing, etc. But often they're not provided very safe and dignified working conditions. Often they're not even seen, maybe. So our project aims to generate, amongst others, policy suggestions and practical tools tailored to support migrant workers in claiming those rights or in seeing their rights improved through one instrument, litigation. And today we have invited 4 experts to share their research and help us answer the question, to what extent can and how can litigation help improve the working and living conditions of migrant workers, including migrant workers in irregular situations. So for us, it's a great honor to have these experts with us during this session. Welcome. Like I said, some rules of the game are posted in the chat. Questions are, of course, welcome. There's if everything went according to plan, there's a Q&A button. Yes, I see it myself. Please use that. If you have a question, you can pose it during the presentation, and then either after each presentation independently, or at least also at the end, we have some room to answer these questions. If we don't get to answer them during the webinar, don't worry. We will distribute the questions among the speakers and see who's best suited to address it at a later stage. But we will definitely try to do so. Like I said, and for those joining, the webinar is recorded. And importantly, I think also of events like this is that you can, of course, look back to the recording, but we also hope to follow up with further information on the topic of strategic litigation. You've already received a list of potential readings on the topic, and we will provide further information as well. So to that end, it would be good if you follow the DignityFIRM project on its website, LinkedIn, and since recently on Blue Sky. We'll have a QR code at the end, but of course you can find us via the website. Okay, I think those are my introductory remarks, and as I say, without further ado, I want to start introducing our speakers. And I haven't introduced myself. Maybe I should just briefly do that. My name is Tesseltje de Lange. I'm a professor of European migration law at Radboud University in Nijmegen, the Netherlands, and I am together with Pascal Beckers, principal investigator of the DignityFIRM project. And as such, I have the honor to chair this session for you. And then to our speakers, we have first Arwen Joyce, and she is at Leicester Law School in the UK, and her research interests are related to migration law, labour law, legal education, also quite an interesting topic. And a lot of her work is focused, if not all of the work, is focused on the Asian context. And we hope to sort of cover the world, or at least a lot of the world in this session. Yeah, let's go to you, Arwen, for your presentation. You'll have to, yeah, there you are. Go ahead.
I'm not sharing my own slides. Oh, there they are. Yeah, great.
Yeah,
Okay, thank you. So it's great to be here. Thank you so much for the invitation. As you said, I'm going to be talking about Asia. So I'm going to look at some cases today that have come up in South Korea and Thailand. So if we just go to the first slide. For a little bit of background. So it was about 50 years ago that Asia's fastest growing economies began to open their labor markets to low-wage migrant workers from mostly their neighboring countries in Asia. And today, Asia contains some of the world's largest migration corridors, including for low-wage labor. So the 7 largest destination economies in the region, which are in blue, but I can talk about more if you want. But if we just amalgamate them all together, they employ about 9 million low-wage migrant workers, and a conservative estimate may be 6.5 million undocumented migrant workers. There are more in other parts of Asia, but just focusing on those 7 biggest destination economies. The common issues encountered by low-wage migrant workers in Asia are all the ones that you would expect. It's the same the world over. I mean, it all boils down to them having very limited bargaining power in their employment relationships and being on very short-term, cancelable visas that are tied usually to one employer, maybe one sector, but usually to one employer. So these are all tied visa regimes, very restrictive, no family reunion, no right to permanent residency. Next slide, please. The case I want to talk about in Thailand, to my knowledge, this is the first case that's gone all the way to the Supreme Court on issues about migrant workers' labor rights. So this case arises from a poultry farm called Tamacaset Farm, and 14 workers from Myanmar were suffering terrible labor rights and human rights abuses on that farm, restrictions on movement, their passports had been confiscated, unlawful salary deductions, really, really long working hours, up to 22-hour shifts. They were working overnight without proper breaks. And in 2016, they filed a complaint with their local Department of Labor Protection and Welfare for $1.25 million US, equivalent in Thai baht, in damages and compensation. The labor inspector investigated their claims and decided to put in an order for just what it deemed were the unpaid wages that it could calculate, because some of them were beyond the statute of limitations that was in place. So the Labor Department awarded them $52,000 US in unpaid wages. Both parties appealed. The regional labor court affirmed the order. The Supreme Court eventually affirmed the order as well. So the workers' other kind of human rights compensation claims were dismissed. Worryingly, very scary for the workers. Indeed, their employer, Tamacaset Farms, immediately after the first claim was filed, started to retaliate. So it pressed charges against 2 of the workers who had taken their time cards to the police to evidence the long hours that they were working. They claimed that was theft, and filed no fewer than 15 defamation claims against the workers themselves, a journalist, other advocates that had worked with the workers and supported their claims. To my knowledge, all of those claims that have been heard by courts in Thailand so far have been dismissed, but nevertheless, quite worrying for the workers. Next slide, please. So this is a landmark legal case for migrant workers in Thailand, just because it's the first one that's come all the way to the Supreme Court, as far as I know. But Thailand is a civil law jurisdiction, so the Supreme Court did not publish a judgment. It just read a statement saying that the labor court's judgment and the original labor inspector's ruling were upheld. The labor court did write a judgment, but it's in Thai and it's not in the public domain. I was able to get a copy of this by getting the agreement of the parties, which was great, and I had it translated, so I've had a read of the judgment. And in my view, the labor court really construes the facts very favorably for the employer. Helpful that they found some unpaid wages were owed, but not so helpful that all those other compensation claims were dismissed for the other various rights violations. I don't really want to talk about it, but just to briefly say there was a case in April 2024 that the Supreme Court again took, which is related to migrant workers. It's about them not being allowed to vote in the Social Security Board elections. The Supreme Court dismissed the workers' claim, but it's not the focus of this talk today. So let's go on to the case in South Korea, or a series of cases in South Korea. There's a couple of cases I want to talk about that are all related to job transfer, labor market mobility. So there are a couple cases that have gone, claims have been made directly with the Constitutional Court in South Korea, which can hear claims directly from people affected by Korea's laws. So they've looked at this issue of job transfer twice. The employment permit system is the current visa scheme in place for low-wage workers in South Korea, and it allows 3 job transfers if they have their employer's permission. And at the time in 2004, when it was first put into place, it allowed 1 additional job transfer if the employer's permission could not be obtained, but it was for something outside the worker's control. So they lost their job because the employer went bankrupt, or the employer was treating them very badly, something like that. There was a list of reasons that could fit into this 1 extra job transfer. Some EPS workers brought a claim on this basis that that limited number of job transfers was unconstitutional, and the court actually found for the government for the way the EPS was currently structured at the time, but nevertheless the government amended the law to allow an unlimited number of job transfers in that case where they couldn't get employer permission, as long as it was for a number of reasons, and they expanded the number of reasons. So it didn't help those workers, but the law did become a little bit more liberal after that. However, that set of restrictions was challenged again, and in 2021, the Constitutional Court upheld the list of reasons that you could apply for job transfer without your employer's permission. So it's still quite restrictive. So I've just got one more slide kind of summing up. I haven't talked about the first case in detail. I just wanted to give you all the names of these cases. You can actually look for the English summaries of these on the Constitutional Court's website. But the one thing I want to point out, kind of from a legal analysis point of view, is that the case that was decided by the court in 2011 set quite a high bar. The government had to have a legitimate legislative purpose and use narrowly tailored means to achieve that purpose when curtailing the rights of migrant workers. So it narrowly found in a 6-3 ruling that the restriction, it upheld the restriction on changing jobs, but said that the government really had to give good reasons. When this similar claim was heard in 2021, the language is a bit different. And to be honest, I'm not sure if this is because these judgments are translated by non-lawyers or if someone's paying attention to this language. But in the 2021 case, the court said limits on job transfers would only be unconstitutional if they were excessively arbitrary and without reasonable basis. To me, that sounds quite different to the narrowly tailored legitimate legislative purpose language we had from the 2011 case. 2 justices did dissent in that case, but that's, so for the moment, the list of job reasons you can change jobs without your employer's permission remains quite limited. And my very last slide for some conclusions. I mean, in Thailand, workers did win their unpaid wages in that really terrible chicken factory case. But they also faced retaliatory lawsuits, and the larger number of human rights violations that they put forward were dismissed. In South Korea, the migrant workers' labor market mobility remains highly restricted, although you did have some useful language in 2011 saying that the government should have a really good reason for restricting migrant workers' labor rights. The government is still given really wide discretion to legislate in this area of how to structure, low-wage migrant workers' visas and what the restrictions are. So I guess my my ultimate conclusion would be that, of course, bringing these cases and supporting workers who bring these cases is extremely important. It's a vital way to pursue justice for low-wage migrant workers. But the benefits for the worker claimants themselves can be limited, and the risks are likely to be quite high. So we saw retaliation in the Thai example. In the South Korean example, all the workers who brought that original claim, and as far as I know, the 2021 judgment as well, all of those workers had, their time in Korea had already ended and they weren't able to stay because they lost that case. So it's useful maybe in a macro sense, but difficult to see concrete benefits for the workers who bring these claims. So, I mean, bravo to them. It's very, very important to do that. But the risks are quite high and the benefits are quite low. So that is my conclusion in the Asia context. And thank you so much. Looking forward to questions and discussion later.
Thank you very much, Arwen, for this concise introduction for probably many of us who are based in Europe of what's happening in the Asian context. Let's see. The idea is that if you have questions, please feel free to use the Q&A, and we can make a little bit of time in between presentations for some short questions, and of course we have time for questions at the end. And I think maybe just to make a connection with the previous webinar we had, which was on the European Single Permit Directive, which is actually has been changed recently, and the big part of the debate was on what our webinar was on this right to change employers. So it's about employer-tied permits still. That's something we will get to, and how to evaluate that in itself. But once you have an employer-tied permit, the question is, how long do you stay with that employer and can you move away? And I think you illustrate that this was indeed one of the topics addressed in these cases, and that it's as restrictive or even more restrictive as it is in the European context. So I think that's interesting to look at. And of course, it's like you say, it's to be cheered that the workers take action, but if it doesn't benefit the workers, then why would they? Is sometimes a question raised. Also, in law, when there's policy or when there's access to justice given, the question is it beneficial for the workers to actually follow that lead? Yeah. Thank you very much. I think those, I don't know if you want to have an additional comment on that observation more than a question from my end. I don't see questions coming in yet.
I guess the only thing I would add is that the background kind of politics in South Korea have also changed between 2011 and 2021, and the politics have generally moved further to the right, which is, I think, a trend that we're seeing in a lot of places now. It's not new, or it's not different. So yeah, I just find overall that the language from the 2011 South Korean case is much more about how labor rights should apply equally to all workers, and the government needs a really good reason to stray from that, versus in the 2021, at least the English summary, talks a lot more about the employer's rights, how difficult it would be for the employers if there was a lot of turnover, if workers kept leaving, how it doesn't fulfill the goals of the scheme. So much less focus in that judgment on labor rights and the kind of general principle that they should be applicable to all in order for them to be useful, basically. So that's a worrying trend that we're seeing in South Korea.
Yeah. Good that you flagged that. Indeed, something happening all over the place. There's a question from Lilana Keith from PICUM. If you could elaborate why the labor rights violations were dismissed in the Thai case.
Yeah, I mean, all we have to go on is the labor court's judgment, which, as I say, I was very lucky to get a copy of, and I had translated into English. I think the reason is that they really they choose to believe the facts are construed very favorably for the employer. So they accept into evidence basically what the employer said about their agreement with these workers. The employer said that the workers were essentially volunteering to stay close to the chickens, sleep in the coops overnight and stay close to the chickens because they'd promised them a bonus if they achieved certain weights for each brood of chickens. So their view was that the workers were not forced to be there all the time, but they wanted to be there all the time to make sure they could achieve those targets. Obviously, that's not the workers' point of view, and it wouldn't be, my reading of the situation either. But I think that was why they found a much more narrow violation, which was that some holiday pay and some overtime pay had not been paid at the correct rate. And every other part of that claim was dismissed. And then because we don't have a Supreme Court judgment that's separate, I don't know, all we know is the Supreme Court reaffirmed the labor inspector's order and the labor court's ruling. So we don't have any other commentary on that, unfortunately, from the Supreme Court.
Okay. And so that's going to the output. And then Sandra Mantou poses a question on actually how these cases are strategic, or were they more individual cases that had a strategic outcome or a more general outcome, or was there a strategy involved?
There's absolutely, yeah, I mean, to the extent that I'm aware, because I was speaking to the lawyers involved in the Thai case, that's how I eventually got my hands on that judgment. I mean, it is strategic in the sense that there are lots of cases that come to them that they help, pursue these claims that don't get appealed and pushed, up through the courts. Just for resource reasons, they have to be, very careful about what they spend their time and money on. So I think that this set of claimants in the Thai case were seen as really sympathetic. They'd been through something really egregious. It seemed like the human rights violations were so obvious that that was going to be a good case to try to put those resources behind. It's absolutely been strategic in the Korean context as well. Those cases were supported by legal NGOs who, again, look for the cases that they think are important to press. It's particularly the right to change jobs is one that goes directly to this bargaining power of the worker in that employment relationship. So that is one that the legal NGOs in South Korea were keen to press on.
Thank you. We have two more questions that I'm going to keep so you can have a look at them, and we'll come back to those at the end, because I want to move on to our next speaker, which is Eleonora Celoria, and she's a lawyer and a member of the ASGI and a researcher at FIERI in the DignityFIRM project. So one of our project members. Good to have you, Eleonora, and the floor is yours.
Thank you very much, and thank you so much for the invitation. I'm really happy to be here, as you said, both because of the research we are carrying out at FIERI within the DignityFIRM project, but also because it is an opportunity to share the work of ASGI, which is the Association for Juridical Studies on Immigration. ASGI was founded in 1990 by lawyers, legal experts, scholars specializing in immigration and asylum law. And over the years, it has developed a strategic approach to promoting litigation in support of migrants and migrant worker rights. So in this brief presentation, next slide, please, I will highlight 3 examples of what we can consider successful litigation related to migrants' welfare rights and to the right to good administration for migrant irregular workers, or at least in a limbo situation. These cases also illustrate different strategies and different roles that a legal civil society organization like ASGI can play within this context. I also want to, before going into details, I want to mention that in order to address discrimination in access to welfare and social rights, ASGI established an anti-discrimination service, which monitors institutional discrimination at national but also at local levels. And based on this monitoring, ASGI engages in different kinds of litigation. So, two preliminary observations, two preliminary points I want to raise is that we need to understand that the primary, one of the most important legal mechanisms used in Italy to promote migrants' access to welfare rights is the anti-discrimination action. It has been this kind of action, this kind of litigation, which is not just promoted by ASGI, but also by other organizations, it has been influenced by EU law, and particularly by Directive 43 from 2000 on race and ethnic discrimination. So following the transposition of that directive, ASGI, the Italian government, Italy, established a registry of civil society organizations authorized to represent migrants in these kind of actions, and ASGI is enrolled in the registry. At the same time, I want to stress that ASGI's approach is to complement rather than replace individual legal actions, and most cases involve both the migrant themselves and ASGI acting together before the courts. A second disclaimer, which I think is useful just to contextualize a little bit the legal context, is that EU law played a crucial role also in securing access to social security and social assistance rights through equality clauses embedded in many directives. And next slide, please. I will focus mainly on two directives, the one from 2003 on long-term resident status, and this directive grants equal treatment with nationals concerning social security, social assistance, and social protection to all migrant workers and their families who have been residing for at least 5 years within the EU territory. More or less, this is the idea. The second directive is the one that Tesseltje mentioned before, so the single permit directive from 2011 that has been recasted recently, and this directive grants equal treatment in social security benefits, recognizing actually the contribution of migrant workers to the union economy. And quite importantly, the directive, so the rights recognized by the directive apply regardless of how migrants enter into the country. So it's based on their status as workers, as far as they are employed or they have been employed for at least 6 months. So let's go through these three examples. First of all, equal treatment for long-term residents. So the directive from 2003 enabled not just ASGI, but many, next slide, please, other civil society to support long-term residents in many different cases. I think there are more or less 40 cases before national courts, challenging discrimination in access to benefits such as what has been called the large family allowance. However, with regard to large family allowance, ASGI alone, self-standing in nationality-based discrimination cases, was quite contested for a while. The National Institute for Social Security, INPS, which has to recognize this benefit, argued that ASGI was only authorized to act in race or ethnicity-based discrimination cases and not in nationality-based cases. However, ASGI challenged a general act by INPS, and then they arrived before the Italian Supreme Civil Court, the Corte di Cassazione, which in 2017 ruled that ASGI had actually a standing alone as association to represent the interest of migrants in preventive legal actions against these general administrative acts, and recognized that it was possible also in cases related to nationality discrimination. Sorry. because ASGI argued that in the Italian context, nationality-based discrimination resulted in indirect ethnic discrimination. Then the court also recognized that since Italian law already stated that migrants should not be subject to race, ethnicity, but also nationality discrimination, therefore excluding the association from acting in these cases would be an unjustified exception. And so it would be in contrast with the constitutional principle to equality. And so this is one of the cases in which ASGI had a self-alone standing in a collective action. The second case I want to present concern the social security rights for single permit holders. And in this line of cases, we can say ASGI played a supportive role in litigation concerning these benefits. So it was not ASGI as an association that brought the case, but several members of ASGI, so different lawyers, supported the individual cases. And so the case was about the right to social security benefits, in particular childbirth and maternity allowances. And it's quite a complex case, but it involved different national courts. So court on the merit, and then the highest court, and then it reached the Constitutional Court, which then referred the matter to the Court of Justice of the European Union, because one of the elements of the case was whether these allowances fell under the Directive 98/2011. The Court of Justice recognized that these benefits were indeed covered by the directive, and since Italy had not restricted in any way the principle of equal treatment between single permit holders and national, that national law excluding them from the benefits was basically in contrast with EU law. And this ruling had a very important, significant impact, because from 2022 onwards, the INPS, so the National Institute for Security, acknowledged that all migrants who hold a single permit, and so who are workers, were entitled basically to all kinds of security benefits. So although ASGI did not have an autonomous standing in this case, we can consider still a kind of strategic litigation, because many lawyers working actually within the Anti-Discrimination Service played quite an important role in this litigation. And then I'll move to the third example, the third case, which is not related to welfare rights, but I think it's quite interesting also because, I'm sorry, yeah, that's a perfect slide, because ASGI with other associations in this case tried a different approach and to use a new tool, which is the class action against the public administration for good administration. So the case concerned the regularization of migrant workers who have been involved in this regularization promoted in 2020. And many workers, many migrants were stuck in a limbo because after 2 years since the beginning of the regularization, the proceedings were not defined, and so they cannot access properly healthcare. They cannot change the employer. They were in a limbo. So also the legal status was not certain, and so they were in a very precarious situation and could not have proper access to social and fundamental rights. I'm sorry. One of the cases was brought in the area of Milan, and in 2022, so 2 years after the beginning of the regularization, there were 19,000 applications out of a total of 26,000 unresolved. And so ASGI, with other organizations and some of the affected migrants and employers, they filed this class action before the Milan Regional Administrative Court, which on December 2023 ruled in favor of the applicant, sanctioning the government for the delays and imposed to the local administration to recognize to end the proceeding and hopefully recognize migrants with a working permit. And I think this is quite an important decision that was actually confirmed last year in September 2024 by the highest administrative court, the Council of the State. And with regard to standing, it's important because both courts recognize that even though there were associations and individuals, they had both a legitimate standing because their interests were legally relevant and they shared the same interest. So I also think this is an interesting tool to experiment, because it allows civil society organization to create a link, a joint action with migrants themselves. So I will conclude. And so this is, I just wanted to present you with 3 different cases in which ASGI played a role. So a collective action in which it has a long-standing, an action in which it's supporting individual, but then this strategic litigation had a quite huge impact on a large group of workers, and then this new class action. And so this is to demonstrate that civil society organization can try different strategies with the aim of supporting the rights of large group of citizens. And I will stop here, but I'm really happy if there are questions. Maybe in the end, I will come to that. Thank you so much.
Thank you very much, Eleonora. I find it fascinating cases. Also, what stood out for me also in this last case is indeed that it was workers and employers and the NGOs working together successfully in this action. And I think often these cases, but let's maybe collect thoughts on that through the Q&A button. Most of these cases it's only the NGOs and the migrant workers, but not side by side with the employers, which is maybe a missed opportunity in many instances to improve also the level playing field that often employers call for in case others are not abiding by the law. What maybe just one question and then we go on. What type of employers were these that joined in the lawsuit, Eleonora?
Yeah, very briefly, they were private households. So because the regularization was both in the agricultural field and in the domestic care sector, and the employers were in the domestic care sector. So there were private citizens, which probably had quite a strong and important relationship with migrants, and so they decided to support the action.
Yeah. Thank you. Yeah, that's insightful. Are there other questions at this stage for Eleonora? Of course, we track your questions, and if they come in later, we will post them to Eleonora further on. And as I don't see anything popping up on my screen, I think that's what we'll do, meaning that we go to our third presenter, which is Eugénie Depatie-Pelletier from Canada. And she's the project director of the End Migrant Worker Unfreedom initiative, also engaging in litigation on the topic at hand. Eugénie, over to you.
Hi, thank you for the invitation. So very briefly, I'm going to synthesize. So the issue started when some anecdotal evidence from Europe, from the US, from Canada was showing that tied workers on work permit were experiencing worse abuses than undocumented workers, such as like wage theft, even sexual harassment, that kind of thing. People were not leaving their employer, instead of what we were seeing in the undocumented workers case, where people actually were going to move to others undocumented work more easily, almost. Obviously, it appears that in case of work accident, the legal workers were better off. But that was kind of a tiny part of the iceberg. Most of the population actually were kind of prone to enduring much worse abuses in when they had legal status to lose, when they had their work permit to lose. And so the first case, please, next. And I'm gonna actually present myself. So yes, I'm a PhD in constitutional law. I work with an association, an NGO association, the Association for the Rights of Household and Farm Workers. And these are the 4 issues that we push. So the right to change employers, but also the right to family, the right to permanent status, and the right not to be held in debt bondage. And so, next, please. We heard about, well, before I go to the UN rapporteur last year, there was a first case in Israel in 2006, and an NGO from Israel went to the Constitutional Court and asked the 20,000 Thai workers coming in the agriculture sector under employer-specific work permit. The NGO argued that this was in violation of their fundamental right to liberty and human dignity. And as in a unanimous judgment, the Supreme Court of Israel recognized that actually this was unjustified fundamental rights violation of workers, that this was modern slavery. And it was a very strong judgment. The government of Israel switched to sector-based work permit. We can come back to that later. But the fact is, it was the first precedent, historical precedent, talking about unfree migrant labor regime in court. And so that obviously took my attention. I went back to study unfree labor regime and how actually courts in history of the world treated that. And it was very interesting to study all the jurisprudence when the slavery, well, first the slavery jurisprudence, it was very interesting to see that it took like a year in court before judges and courts and dissidents basically found that, you know, slavery maybe not that a good idea for free labor, for free workers. Even to have unfree workers beside them was not a good idea for the society. But it took literally 100 years of courts and battle in courts. And so when actually slavery was abolished, you know, throughout the world, especially in the United States, where the courts were active in that regard, it was very interesting to see the jurisprudence in Alabama, South Carolina, Missouri, Florida, all of these states, they all came back after the slavery was abolished with new ways to have unfree labor regimes. Basically, other kind of state sanction when workers quit their employers. It was mostly imprisonment, but there were other ways to also sanction the worker and make sure they would not quit. And you know, all this jurisprudence on the right not to be held in servitude was very interesting and instructive on the fact that, well, you know, free workers is important, not just for the worker itself, but for the whole society, labor market, employees, you know, competing between themselves to have decent work condition and all. And so basically, these unfree labor regime for permanent resident citizens kind of went out of the picture. But during the World War II, everywhere in the world, including in Europe, everybody brought back these unfree labor regime, but for foreign workers. And what is interesting is that if they've never, until the 2006 precedent in Israel, they've never been, you know, in court for a different reason, mostly because these were in ununionized sectors. well, and also because they were non-citizen workers. And so this first Israeli precedent, of linking closed work permit system to modern slavery was very, was a big precedent. And so in Canada last year, the Human Rapporteur on contemporary form of slavery came and issued a statement and then a longer report saying that the Canada's closed work permit system was breeding grounds for modern slavery. And also that high wage and high skilled workers were also very much put in a place where they could not exercise fully their rights and places of abuse, because there was this fear of losing, obviously, sponsorship to maintain their status in Canada and or access permanent status. Please, next. So what were we to do in this context? How do we find a way for workers to be free and not modern slave in Canada? So next, please. Well, actually, we don't have much time, so I will skip just quickly, briefly. Canada's I've had unfree labor regime forever. I mean, since the beginning of the colonization. Obviously, it brought them back in the 60s when they allowed Black workers from Jamaica. So initially, unfree labor regime and closed work permit were only targeted to Black workers. But then they were open to, mostly global South countries, not white countries, so that they were all coming into Canada, but only on tied work permits. And so they have been justifying this regime of unfree labor by saying that, they were this monitoring system that was, doing inspection on employers that were allowed to sponsor migrant workers. And also regulation for recruiters acting on behalf of employers. In some cases in the agriculture, there were also this initiative of having sectoral permit where actually employers can had sponsor a pool of workers for them and, can switch and transfer them between themselves at will. But all of that now we've had like 60 years of social science evidence of anthropology, sociology, political science, law researchers, but all sorts of research, human geography now are the abundance of data that we have on human rights abuse of these tied workers is amazing. And because we have 60 years of evidence, and now it's not just domestic workers and agriculture workers. Obviously, it's in all occupation, in all sectors. Employers are totally addicted to unfree labor. In some factories now in Canada, it's 80% unfree labor and 20% of citizen free workers. And so even if they have a collective agreement, no worker is has the capacity to stand and ask for like the respect of the collective agreement, because of course the employer knows that it just don't have to not to sponsor the worker again. And so it's now very clear in now unions are like, it's been a few years, are like very alert, because they understand and that it's very addictive for employers to have people that are depending for the whole status on you. Okay, so So what did we do? We launched a class action, but it's well, actually, please, next. I'm going to go right away to comparing what we're doing with what happened in South Korea. Because, so again, in Israel, there was this very unanimous judgment in 2006. Then there was another decision in Israel that actually said, but if there's a bilateral agreement, if Turkey government send Turkish workers in Israel, then it's okay if they're only tied to one factory because, you know, the government is there and there's some oversight. So that was like a nuance for another judgment in Israel in 2007. But then South Korea, we just heard about that case. The Supreme Court decided that it was actually justified for the government to protect citizen worker to have this unfree labor regime, just to protect citizens from job stealers that the migrants are. So what were we going to do given this context, given this huge jurisprudence in United States and in North America on the right not to be held in servitude, on the right, actually the Supreme Court of the United States in a 1944 case was very strong and vocal about the fact that the right not to be held in servitude required the right to freely change employers, and why this is key and important in a free society. And so what we decided to do is to build a case that was better from the Israeli decision and case, which was only on the work permit, because what we've seen that the Israeli government actually right after kind of changed a comma and create a new unfree worker regime. And so now what we've challenged in Canada is the authority to tie the worker in any way, not just closed work permit, but in any other form of measures. And indeed, there is about, in my legal thesis, if you want to read it, there's about like 25 ways in which you can tie a worker to the employer. Closed work permit is only one way, but there's a very different way in which you can ensure that the worker is going to be sanctioned if he leaves the employer. And so we went to the regulation, the legal authority for the federal government to tie migrants, and we challenged that. And we launched a case in 2023. We've been authorized to represent about 2 million foreign workers, and the Quebec Supreme Court, Quebec Superior Court just authorized us as, our standing to represent the migrant workers, and also the legal question, which is it the prohibition to switch employers, is it compatible with the fundamental right to liberty, the fundamental right to security of the person, so both physical integrity and psychological integrity, and also the equality, so the right not to be discriminated on the basis of national origin, because we do have French people, UK people, everybody's coming in with open work permits to Canada. But if you're from Guatemala, Mexico, Philippines, whatever, then you're bound to specific employers. So that we have really different ways of treating migrant workers and immigrants coming in. And so just on the face of it, the regulation is discriminating. And so—
Can you wrap up, Eugénie?
Okay, yes. So we're asking damages. So we have a capacity, on this right not to be held in servitude to liberty, we have a capacity to ask for damages. And damages is not, just a little bit of money for everybody, but it's also the fact that it's going to be, the idea is to dissuade foreign future governments to reestablish unfree labor regime. And so I can answer further question and clarification in the future.
Thank you very much for this elaborate historical and current actions taking place. So we'll come to your questions in a couple of minutes. But first, I want to give Kris van der Pas the opportunity for some final reflections. Kris just did her PhD on the topic of strategic litigation with us here at Radboud University. So proud to have you back. Now a postdoctoral researcher at Tilburg University and coming to us from New York. Kris, some thoughts from your end.
Yeah, thanks very much. Thanks to all the presenters and to the presentations. I thought they were very interesting. And I don't have slides. I just want to kind of tease out some aspects that stood out to me. And I'm going to focus a lot on, I think, the socio-legal, which is what I'm interested in, right? Also, how strategic litigation as a phenomenon kind of works, and drawing some links between all presenters. So I'm going to start a bit negative maybe and then end with the positive. So first I want to kind of place emphasis on, well, there's first, of course, the conceptual thing, which was also a first question that was posed, right? What is strategic? What does make litigation strategic? Which is, I think, an important thing to take into account. But what stood out to me here is that all of these litigations are really focused on policy change. They're not just focused on the individual. And I think that's what here makes it very, very strategic in that sense. A first kind of overarching thing that stood out to me is the importance of law, and that might make sense, but also the importance of procedural law. Several of the actions we saw here were class actions. So there's of course really a possibility to pursue for a broader change. You know, as an organization yourself, you don't need the individual, which makes, I don't want to sound like you of course need the individual, but it can make it easier and prevent a lot of accountability problems where you need to balance your client's interest with the strategic element. Of course, if you have this class action, it's not necessary, as the Italian example also shows, right? There's multiple ways of doing strategic litigation, but that stood out to me. A second thing, and this is the most negative part, you're of course fighting against, it's David versus Goliath, right? You're fighting against either the state or the company. So one colleague where I'm writing a paper with remarked, the house always wins. I think this is a very grim picture to draw, but in a sense, of course, the government has the power to change the law, to create new policies, to, so you keep fighting, and at the same time, you're also required to balance also these attacks on the judiciary and not over ask the judiciary with these cases, because then they might start replacing judges, and then you're even further away from your goals. The third point I wanted to make is the point on accountability that I just mentioned, and vulnerability, because I think what is also very important here is that you need this legal support structure from lawyers, from NGOs, in order to challenge these issues. Migrants and migrant workers especially are very vulnerable. They're also, as the Thai example shows, they're in a vulnerable position because they are employed, and you shouldn't bite the hand that feeds you, right? Because then you might face the repercussions. In any case, you're probably going to lose your job, which is already a very serious thing to take into account. And so there, I think there the strategic and the legal world can really come in to change things. Now, moving to the positive aspect, as I promised in the beginning, I think what research on strategic litigation has shown, and I think something that hasn't maybe come up here, but that could be an important element, is also that strategic litigation can have a lot of indirect effects, right? We're looking for the direct effect. We're looking for the policy change. We're looking for the big grand, improving the rights of migrant workers. But at the same time, what strategic litigation, especially migration, has shown is that it can also empower people. It can give people a language. It can give people, a certain feeling of I have rights. I have, just learning about these rights can already, start making change. And even though this change is not directly tangible, I think it's very important that, this is how unions were created in the beginning, right? You need to have this language, you need to unionize, you need to be aware of what your rights are, and in the collective is also then the power. So I think this element of empowerment and of giving people rights is an important one. And I think that the last point that I wanted to make, which also research has shown, and what I've also seen in my own research, is, pushing for change is a very burdensome and long process. But incremental change is also worth something. Maybe you don't win, on the larger point, but if you have a legal argument that comes out of this case that you can use in subsequent cases, that is also a win. And I think that that is also a very important thing to take into account. What is the long-term objective? What is the long-term strategy? And pushing for these incremental changes can lead to more change in the future. I'm going to keep it at this because I want to leave room for the Q&A. But thanks so much. I thought this was very interesting.
Thank you, Kris, for synthesizing a bit of and bringing together these talks and highlighting some, I think, very important aspects that can also be taken on board in both research as well as future actions. Yeah, we're just showing the QR codes of the project. So if you, like I said at the beginning, want to follow along, please do so through these channels. But we've planned to have another 10-12 minutes for Q&A. We still have 2 questions out that I want to first put to Arwen. And one was on, so in the Asian context, and I think interestingly also looking at Eugénie's example, where there is a declaration, at least from a UN representative on that is very useful for your case. The question here is if cases or complaints before the ASEAN or the UN human rights bodies have been part of the field in the Asian context.
Yeah, thank you for the question. It's not something I focused on in my presentation, but I did put a couple of links in the Q&A box in response to that question. ASEAN does indeed consider these issues quite frequently, and I think the link I put in is about migrant fishers. That's from 2023. They, passed some resolutions about how those migrants should be treated in ASEAN. But important to remember that some of the main kind of destination economies in Asia are not part of ASEAN. So South Korea, for example, is obviously not in that body. But yes, that's an important forum where Southeast Asian destination countries and sending countries are able to talk to each other. So I do think it's important. In terms of UN human rights bodies, there is the UN Human Rights Council's Universal Periodic Review process, and NGOs are able to submit reports to that process, as well as the countries, submitting about themselves and how well they think they're doing on their human rights issues. So migrant workers are often mentioned, especially live-in domestic workers, low-wage migrant workers, farm workers, often cited in those reports. The only other thing I would say is that there is obviously the Convention on Migrant Workers' Rights, but none of the main destination countries in Asia have signed that. So it's a little bit less useful, although obviously it does embody some useful principles that people can still bring up in litigation.
Yeah, thank you, Arwen. And that conclusion on that treaty also goes for the European context, where ratifications are low, if not absent. But I agree with you that for inspiration, it's an interesting document to read what the rights of migrant workers should be. Of course, yes, Siham, we still have your question out as well. And then I will come also to Eugénie. You raised your hand with maybe a possible reflection on Kris. But first, Siham's question, which is a very broad one, maybe to all of the presenters, is if you have suggestions for either labor unions, NGOs, legal aid organizations on how to collaborate, how to set up such collaborations, so that it is working towards a more sustainable change, if I may summarize it like that. And I think, Kris, you address that a little bit at the end. The sustainability might not be the big thing that you're working on, but it might be small steps. But maybe each of the speakers wants to reflect a little bit on that. Can I maybe start with you, Eleonora?
Sure, yes, of course. Well, I think that already I'm sorry, that already sharing the positive outcome of litigation, which has been promoted by one or another organization, it can be quite useful. As we have seen in the last case I presented, there was a coalition of NGOs that gathered together, and also to have different NGOs and maybe also unions help to get more contacts with migrants themselves, because I also think it's quite important when we promote these strategic litigation to take into account, as we've seen already, the situation of migrants, and so to try to promote litigation which has a broad impact, but also to take into account the interests of the applicants and the person involved. So to gather and to share experiences among NGOs, I think at the European context, both national NGOs, but also at the EU level, so to share good litigation cases between different member states can be a way maybe to go forward.
You're muted, Tesseltje.
Thank you. That is indeed what we intend to do within the DignityFIRM project and with our partner PICUM, who are working with NGOs on the ground and with migrant workers on the ground. Yeah, good point. Arwen, do you still want to get back to this general comment as well, or shall I go to Eugénie? Please.
I think I'll let Eugénie take this one. She's better placed to answer it than me.
Okay. Eugénie, on the general question from Siham on how to cooperate in this, maybe just on your experience on who you are cooperating with and how you're organizing that, and then we're wrapping up.
Yeah. So I'm a bit pessimistic for migrant workers with access to justice and litigation in general. In Canada, the only thing that has worked is when there's huge work accident and you have the worker compensation board who have, staff lawyers who will go against the employer to get some, minimal funding for the injured workers. This is the only kind of, point of the iceberg in which we've seen justice almost. For all the rest, the position of workers is very, as you know, very weak. And so to go against a big employer is kind of usually, well, it didn't, well, this is the reason why NGOs are so key and important and must, have standing. So anywhere they have standing, I think this is where all energy and resources should go. And yes, strategic litigation become important because, to go and try to, for one person, two person, when we have millions of people that are in a situation where the abuse is just the rule, so I just want to talk about money. It took us, as I talked about, this case in 2006 in Israel. So we knew that there was some legal argument for any jurisdiction when there's a right to not to be held in servitude, like in the European Convention, or the right to liberty as in Canada. But we didn't have money. So for like literally 20 years, we were waiting. We had all the legal arguments. We had all the university researchers, like free experts, like in line to come to court to testify. But we didn't have like the money enough to fight Canada. And so this is where actually, what we've seen is that you need constitutional lawyers, you need immigration lawyers, and you need class action lawyers, which is very rare to have in the same room, these kind of people. And so this is where, when you can have class action lawyers who see that it can get a share, like in 10 years of like a percentage of like whatever big class damages, this is where it becomes sustainable. So it's only because we have the best litigation firm of Canada working, without being paid, that this whole thing can actually go on. So the whole class action makes it logistically feasible. And unless you have that, I would not recommend for any like real access to justice. This is always, as you said, you know, David against Goliath, and the odds are very low. But even when you have the strong, everything, of course, it's a bargain to go to court. And you know, Abraham Lincoln faced the Supreme Court of the United States saying slavery is right, slavery is constitutional. So of course, you never know which kind of judge you're going to have when you go with human rights. But what's interesting, if you need to go and keep fighting, because yes, there are some dissidents that will at some point 20 years later become, you know, the majority. And this is what strategic litigation, I mean, it's important, not necessarily because it's going to be a for sure win, but it's because we need to set the dialogue on the real terms. This is on free labor. And so unless we talk about the real thing here, it's always going to be, you know, tinkling around the edges of the real structural problem, you know, creating abusable workers. And so one last thing, I just wanted to say that the South Korean case lost because it's very easy to show human rights violation for migrant workers. What is not easy is to show that it's not good for society, that it's unjustified for citizens. And, you know, in South Korea, there was no evidence of the impact on the South Korean workers. And this is where actually now, after like 60 years of evidence, we can, and gold mines in, you know, the United States and anyway 200 years ago, free labor and unfree labor. So now it's very important to show the impact on free citizens, so that, you know, it's pressuring the labor conditions, and so I think this is the other part of the evidence that is really important.
Yeah.
Thank you.
Thank you very much. And I think with those inspiring words, where you're full of the fight, Eugénie, I think we're going to close this this webinar. We have some questions still out more on whether the slides will be shared. The answer is yes. We will make a summary of the event if you want a quick read. So all of that will be available through the website of DignityFIRM. And furthermore, as a final note, this is, like I said, one of the joint webinar series, and the next one is planned for March 6th and will be hosted by our partners at MIRM, which is about evidence-based and their data collection for policy making on irregular migration. With that, thank you to my speakers. I thought it was fascinating to hear you, and also in the preparations, it was great to join forces. And I think to all of you, we have shared a document with some literature. Please feel free. It's a shared document to add information that you have from your background, from your research or activities as an NGO or otherwise, that you want to add to that list, so that we can build this knowledge base together, and in doing so support those NGOs or activists who want to take action, or the migrants who don't have the funding yet, but then at least the knowledge is not difficult to obtain. With that, I'm going to close. Thank you very much for joining. Have a wonderful day, and hope to see you in one of the next events. Goodbye.